Hello and welcome to Let's Pod This. My name is Andy Moore. This is the second episode in our three-part series about criminal justice reform in Oklahoma. In our first episode, we visited with criminal justice policy experts to lay down a foundation of data about the criminal justice system here in Oklahoma. And now in this episode, we're joined by criminal defense attorney and government transparency advocate Brian Jones to talk about the fines, fees, and, well, how our current system kind of creates a trap where people who commit even just a small legal infraction can get caught, and it may take them years or thousands of dollars to get free, if they're able to get free at all. I know for Scott and I, recording this episode was very interesting and very illuminating about some of the realities that Oklahomans face when they are interfacing with our criminal justice system, even at arguably the lowest levels. So buckle up, and I hope you enjoy. Today we're joined by Brian Jones.
Hey.
Who has, welcome back.
Yeah, good to be back.
Been here before. Brian, so we wanted to talk about fines, fees, how those relate in Oklahoma to other states, what it means for the people, and kind of what the impact is. There's been a lot of discussion about reforming the fines and fees in Oklahoma. And as we were getting ready, you started to say that maybe a good place to start is by what it means for someone to be on probation.
Yeah, just as a practical matter, what happens to a person when they go on probation? Well, this is how I do it in Oklahoma County. So you'll have the final day for your client's case. Either it's a regular conference docket, or you've set it specially for a plea. There's a lot of paperwork that goes into that. There's what's called the Lumpkin form, which is if we're talking about felonies, the Lumpkin form, named after Court of Criminal Appeals Judge Charles Lumpkin. And it is a stack of pages that a lawyer is supposed to fill out with their client, go through it with them, and explain all the different aspects of what it is to enter a plea. It can get pretty detailed, depending on lots of different factors in the case. There are some specific things you have to go over. For instance, if it's an 85% case and your client is not going into probation but going into prison, you have to let them know this is 85%. It's in the paperwork. You have to check that box.
And what does that mean?
An 85% crime is a crime in Oklahoma where the prisoner has to, by statute, serve 85% of the sentence before becoming eligible for parole.
Okay.
Yeah.
What kinds of crimes might that be?
Imagine about what you would expect.
Bad ones.
Murder,
That's pretty
rape.
bad.
Sex offenses are usually on there. Violent crimes are usually on there. But even aggravated trafficking in controlled dangerous substances, so a drug crime, is on there, and just all the crimes that are subject to that statute are listed in the Oklahoma Code.
But this. And for 85% crimes, so I know like with some sentences, you can be sentenced to like 10 years in prison, but if you don't get in trouble and like you go to classes that they offer at the facility, like you can earn up to 3 days, right, of credit for every like actual 24-hour period you spend incarcerated. And so you can serve you can discharge your entire 10-year sentence in like 3.5 years, right? Can you do that with these? So with 85% crimes, if you're sentenced to 10 years in prison, you will be incarcerated for 8.5 years.
It's day for day up to the point you hit the 85% mark.
And then you can get the kind of the 3-for-1 kind of, or whatever the case may be.
There may be some restrictions on your eligibility for credits if you've been serving an 85%, if you're on an 85% offense. But yeah, those special credits don't apply for those folks. So it's like in the federal system, whatever your sentence is, you got to serve that day by day, and it's the same with 85% offenders. But so you get the paperwork, right? You go through all of it. They have to acknowledge the constitutional rights they're giving up. They have to say whether or not they believe their attorney has effectively assisted them. And so there are all these little boxes you got to check, and you got to have them sign it, and you got to fill out a couple more forms. One of them is a form that just says, here's the terms of probation like they're going to do community service. They're going to be doing it for this long or that long. They're going to be paying this much in restitution. There's a separate probation form. There's a separate form called a Rule 8 form, which is where that's the form that basically gets you a payment plan for your fines and court costs.
Okay.
So you go through all that. You go over that with your client. You go over that with the prosecutor. Everybody make sure that the paperwork is correct. You take it up to the judge. The judge goes through it, brings your client up, runs, swears them in, runs them through it, enters the plea, pronounces probation. At that point, and only at that point, does the like probationary sentence begin. And really it begins when you take your client physically from that courtroom and walk them in Oklahoma County down to wherever they're going to be doing probation. If they're doing it through the DA's office, there's a DA probation window. If they're doing it through DOC, which if you're serving probation on a suspended sentence, meaning a felony conviction, usually that's done through the Department of Corrections, which is in a separate office. But you get them set up on that. And then as a separate matter, you go get them set up with the court clerk cost administrator. And that is a brief interview between the probationer and the court clerk cost administrator to determine how much they can reasonably pay on those fines, fees, and court costs. Because as a general rule of thumb, even a relatively simple misdemeanor case is probably going to, by the end of it, generate about $1,000 in fines, fees, and court costs.
Okay. I was going to ask what are the typical fines and fees in Oklahoma, and how does that compare to other states?
I don't know exactly how they would compare to other states, and it's a lot of little things that add up. Like there's these different funds. Some of it goes to the courthouse, some of it goes to other different entities somewhere else, but it all adds up to what can be a pretty substantial new monthly obligation that the client has to pay.
Sure.
So,
Go ahead, Scott.
Do these costs and I'm not talking about fines and fees necessarily, but the specifically court costs, do they reflect actual costs or is it arbitrary?
Well, I mean, they reflect costs that have been statutorily mandated. I mean, to that extent, they've been determined to be needed. Right. And some of them do go to fund.
I guess what I'm saying is like, is it determined like that the court is like, okay, last year the court spent $10,000 on paper, and so this year the court cost for paper that is used in court, like, is there any relationship between court costs and what it actually costs to have court be a thing?
That's a good question, and I think the answer is absolutely not in any sense whatsoever. Like I think that
that's ridiculous.
Well, so matching the court costs to the courthouse budget would just be, that would be a very difficult kind of on the fly operational thing to accomplish. But you'd said something about what it actually costs to run the court, or what the costs go to. Like, for instance, every person who is subject to criminal probation in Oklahoma is going to pay some kind of fine for the offense itself. That's part of the penalty.
Sure.
They're also going to pay what's called a victim's compensation assessment. And so that's an easy example of kind of what you're talking about, because the victim's compensation assessment goes into the victim's compensation fund, which is a separate fund administered by the DA council that does get used to compensate victims for things like, funeral expenses in the case of a murder, for instance.
Sure. And so, and that makes sense to me, because like the fine is a fine, right? Like it's not paying for a cost that has been incurred by somebody. Like that is part of your punishment, your penalty for the crime that you've committed, right? As is like, I think you could say that the victim's compensation fund is both, right? It's part like punishment and also part like paying for costs that have been incurred and borne by someone else because of the crime that you've committed. But it seems like the costs for court should try to bear some actual resemblance to, like, if we're gonna make criminal defendants pay for the cost of court, it should like maybe reflect a little bit what court actually costs. Like, I personally think that, like, I don't know. I mean, I think that you should run court like they should have, like the justice system should have its budget, and like you should budget how much the court like You should. You know what I'm saying? It's like to me, they shouldn't be connected. But if they are connected, they should be like they should have some like reality. Like there should be some.
Just quickly, I think one of the problems there is that court costs are largely set by statute by the legislature, and the budget for each courthouse is established by district judges, and so there's the district judges kind of have to do what they can to run the courthouses with the funds they have, and frankly, I've spoken with judges throughout the state that really are struggling to run their courthouses because even though the fines and costs, the fines and cost burden on individual human beings are really high, in lots of circumstances, it's not enough to fund an adequate justice system.
Sure.
Well, and because as you mentioned, the court, when we refer to the justice system or the courts, it's not just the time in the courtroom; it is the people in the the office where the court clerks. Payment office, bailiffs. It is in the parole office. You have to pay all the support people, which is what's funny to me to be sitting here between an attorney and a physician and discussing about how payment systems are operated. We'll get back to how healthcare costs are operated in a couple of months in our healthcare series.
Well, I mean, it's totally ridiculous. I mean, the way that healthcare costs are tabulated is absurd, but and you're right. That's a whole other like discussion. It's just as interesting to me that like, if you get a traffic ticket in Oklahoma City, you're going to pay, whatever your fine is, and then you're going to pay court costs, and it's going to be, I don't know, like $80 or something. I'm knock on wood, it's been a minute since I had a ticket, but like, let's say that your court cost on top of your fine is $100, right? Like, you're saying, Brian, it is $100 because the legislature has said the court cost for a traffic ticket is $100, not because you can take that $100 and say $10 of it was the judge's salary, $5 of it was the clerk's salary, $2 was paper. It's $100 because like somebody pulled that number out of the air and said this is what it costs, or this is what we're going to say it costs.
Yeah, I mean, kind of. I mean, like for instance, one of the costs you pay is like a law library fee. There's those costs do go towards a thing that actually exists and can be pointed to. But as far as like matching those up, yeah, it's not really how the budgeting process works.
That's so interesting.
Well, and I would imagine, I think part of the concern about fines and fees in every state, but certainly in Oklahoma, is that there are such a large number of these fines and fees.
Yes.
And for this matter, a large number of these fees, like the law library fee, that are not directly related to the punitive damages or to the offense itself, right? Like if you embezzled $1,000, you got to pay $1,000. That makes sense. Maybe you got to pay an extra $300 as like extra punishment,
right?
But none of what you did affected the law library. And so is some of the fee structure in Oklahoma and maybe other places designed because we don't fund things like the law library, and so we decided to shift those costs to offenders.
Right. Yeah, away from the taxpayer onto offenders, and that's like an easy political sell, but it's not good government. One of the things that DAs have been pretty clear on here in Oklahoma is that they don't want to run their offices off of fines and fees and court costs and things like that. Right. They would rather be supported by the legislature. They should be supported by the legislature more than they are.
Which is interesting. I mean, I made a joke a minute ago about healthcare funding, but that's a big difference in healthcare. That Scott works in healthcare as a physician, and I don't know how he's paid, but I assume in most cases it's like a fee for service, and so you as a patient you pay, and that goes into supporting the providers that are working there. Yeah. I've worked in healthcare for 10 years, but I've worked under a federal grant, and they just give us a block of money and then say, see everybody you can. Yeah. And so, and in theory, you could see a few people and make extra money. That's not the way it works. You see everybody you can, and that's like a more efficient use of money. So we end up being a more efficient program because it's not a piecewise thing. Mm-hmm. So to kind of bring this back to, maybe some of the crimes that are being talked about in criminal justice reform in Oklahoma, things like simple possession, things that were crimes that are not crimes now.
Yeah.
What as a expert in that area, go back 5 years or so. What were the typical fines and fees that a client might experience if they were arrested for something like that?
Well, a person arrested for simple misdemeanor possession in Oklahoma 5 years ago, that would have been what, 2014? Okay. If they're if they're going through a regular county district court, not through any municipal court, they're first of all going to probably have to pay $100 to a bondsman to get out of jail, because this is something that we were locking people up for pre-trial, even after 788 passed, actually. So that's the first thing that's the first cost that they're going to incur.
And that's assuming their bond was only like.
Assuming their bond's $1,000, which is a pretty standard bond for
possession,
simple misdemeanor possession, which is that's $1,000, right? Somebody's got to pay that, and unless you can pay the whole thing up front in cash. And let me just pause for a second. So there are two kinds of bonds. Well, there are three kinds of bonds in the criminal justice system. There's an OR, or an own recognizance or personal recognizance bond, which that just means you are released on your promise to return. You're released on your own recognizance, right? Then there's a surety bond, which is a bond posted by a bondsperson on your behalf after you've paid a premium, which is 10% usually, so $100 on a $1,000 bond. There's a cash bond. That's where you yourself go to the courthouse with $1,000 cash and hand it over to the court clerk. Which of those options, I mean, just putting aside the OR/PR bond for a second, but which of those pay bond options, surety bond or cash bond, do you imagine is probably better long-term for the individual person, defendant, going through the system?
Well, is there an interest involved in the surety bond?
Not necessarily. I'll just jump ahead. I'm sorry to ask a
go ahead.
rhetorical question. But no, like if you post the full amount as a cash bond,
right,
that gets applied to your fines and court costs at the very end. So the same money that gets you out of jail, if you have it, goes to satisfy your fines and court costs at the end. So it's like
a prepayment.
Yeah, it's like a prepayment. But if you don't have the $1,000 to go pay a cash bond, you got to go pay a bondsperson. That's $100 out of pocket. You don't see back. They post the bond, but that bond doesn't get applied towards your fines and fees and court costs. You got to pay all that stuff. So, anyways, I'm sorry. You got to.
Yeah. So what if Andy over here, gets himself arrested for something?
Yeah.
And he's got a $1,000 bond, and he calls me up and says, "Hey man, I'm in a bad way. I'm arrested.
Mm-hmm.
You got $1,000." And I say, "Well, just because it's you,
Right.
Right." And so I go post a $1,000 bond on his behalf. Like, does that money that I put up go to his fines, fees, and court costs, or do I get that back?
You would get it back when the bond's exonerated, meaning the case is over and we know what happened. That bond is exonerated to go back to you. If you wanted to allow it to stay with Andy to cover his fines and fees, then you could do that. And,
okay.
But so your first cost is your bond, unless you can post a cash bond, right? So then your next cost is actually the time off work that you're going to have to take in order to be at your first arraignment setting. In Oklahoma County, you get 2 arraignment settings because regularly the charges aren't available until the second arraignment setting, which actually, even then, the charges may not be ready, so you may have to wait for another arraignment setting down the line. So you've paid $100 to a bondsman, and you had to miss an afternoon of work to go to your first arraignment setting. You didn't get arraigned. You got to take another half day off work to go to your second arraignment setting. Let's assume you got arraigned at that setting, right? So you got to go get a lawyer, and you got to take all the time that it takes to go.
So you don't have one yet at your
You don't have one yet. Yeah, you know why? Because you bonded out, remember? When you bond out, you are presumptively ineligible for a public defender.
Even if you only paid 10% of what you bond.
Yeah, even if you only paid 10%.
Wait,
even
so
if your
if you-
family had to empty the couch cushions and scrape together everything they had
to get $100 to a bondsman
to come up with that $100, you are presumed ineligible for a public defender if you post bond. I don't think this is written down anywhere.
We try not to cuss on the show, but I'm gonna just go and say, like, earmuffs, everybody. That's some bullshit right there. Like, that is some hardcore bullshit.
I mean, it's just, as long as I've been in the Oklahoma criminal justice system, this has just been kind of an unwritten understanding that if a person has the money to bond out, they're presumed to be able to afford to hire a lawyer.
Wait, but it's not statute. Like, that's not like
that. You probably can't write that down.
Huh.
But how do I guess? Well, then this is just like I mean, and I know I'm like constantly sidetracking us here with questions, but like, how do you get a public? Like, I thought you got a public
Stay in jail.
Which is so that's why people stay in jail, is because they like. Let's say I was arrested for something. I've not been, but I was truly innocent.
Okay.
And I just happen to have no money, that's more plausible than me committing a crime. So I'm innocent, and I know I'm innocent, and so I have to just sit there, because even if my mom sells her wedding ring and gets $100 to get me out, we couldn't afford the attorney after that, right?
It's a challenge. Attorneys are expensive.
Sure.
But you can't. I'm just still like flabbergasted at the idea that like you can't just appear at the court and be like, I would like a public defender. I can't afford a lawyer. You can't do that.
You can, but you're going to be denied in all but the most extreme occasions when you have very good documentation of how in the world you were able to bond out and why in the world you can't afford a lawyer even though you're able to bond out. So the application for a court-appointed attorney is one that a lot of people who have bonded out have to go through and fill out. And sometimes it does get granted. Yeah, I'm not going to say it never happens, but it is definitely the exception.
I thought that was like in the Constitution or something.
Totally is. Totally
that you get a lawyer.
Yeah, you have the right to a court-appointed lawyer if you are indigent. And if you are not indigent, then you do not have that right. And again, the call is this person indigent? And in our system, that call gets made pretty
subjectively,
pretty categorically on whether or not you were able to bond out.
Okay,
that's messed. That is.
So yeah. So now you've
that is messed up, man.
You've gotten arrested for this thing that's about to be legal but you don't know that because it's 2014. And why in the world in 2014 would you think that possessing marijuana is going to be legal in Oklahoma in 5 years? But so you've been arrested for it. You've paid a bondsperson. You've missed work to go to your arraignment setting, and you've done the work to hire a lawyer that you can afford. So that lawyer then goes and let's just say that you skate through, right, and you get a deal that you can live with on the first day your lawyer goes and talks to the DA's office. Now, because this is misdemeanor possession of marijuana in 2014, that's probably going to look like a 2-year deferred sentence with supervision through the Oklahoma County DA's office, along with a $300 fine, 40 hours of community service, victims compensation assessment, right? Court costs, all that stuff.
What, victims compensation assessment?
That's the thing we were talking about earlier.
Yeah, but who's the victim of my possession of marijuana?
The society is
kids.
The victim.
Scott,
kids. I have seen in drug crime paperwork somebody list society as the victim, and the address provided was the DA's office.
You're like blowing my mind over here. I'm just like, this is like exploding.
Okay. So you get a 2-year deferred sentence on this misdemeanor marijuana arrest.
For our listeners, Brian keeps gesturing at me as if I'm the one that's had the as the object of this story.
Well, I mean, I think I made it pretty clear that you got arrested.
This is your case,
and asked me to bond you out,
ruining my life. All right.
So you've got a $300 fine. You've probably got a $50 victims compensation assessment, even though the victim here is society, and that money can't actually be used to compensate the victim of Andy's crime. It will go to compensate the victim of somebody else's crime. Right. So let's say we're going to get all that done at your first court setting. So you're going to have to take another half day from work to go to the courthouse and go through the process of doing what I described at the very beginning. Going through over the plea paperwork, going up in front of the judge with me, and then going to if this is DA supervision, you're going to the Oklahoma County DA supervision office and getting all that paperwork done. Then you're going to the court administrator, and you're going to leave the courthouse owing for a misdemeanor marijuana possession easy. You're going to owe $1,000. Combined fines, fees, court costs, potentially A little more.
And so
On top of the 3 days of work that you missed.
On top of the 3 days of work that you've missed, $100 you paid to a bondsman, and whatever you've ended up paying to your attorney who negotiated this for you.
And for what you just described, what would be typical that you'd owe to an attorney?
You can get an attorney for something like that. Well, different attorneys have different ways
totally.
of...
Sure.
Some attorneys would say, I'll do this for a flat fee of like $1,000, $1,500.
Right. Mm-hmm. Sure.
Other attorneys are like, you're just going to pay me $100 every time we have court. And there's a great deal of gradation in capacity and skill, talent, knowledge.
Sure, yeah.
Different attorneys.
But I mean, but you could, but it's not. It is not at all unreasonable to think that on top of the $1,000 that you're out to the court, the 3 half days of work that you've missed, you could absolutely pay $1,000 to a lawyer to assist you with that process,
and that would be on the cheaper side.
Yeah.
Okay.
Sure. So somewhere from 1,000 to 5,000, maybe.
5 would be. I would say 5 would be high for a misdemeanor marijuana case,
right.
but I'm sure that fee has been paid to some lawyer at some point for that.
Just
offense.
wish it was you, don't you?
So you go through all that, and then now you've got 2 years in which you not only have to keep up with all these obligations to the court, but you have to pay $40 a month to the DA's office for supervision. If this had happened a year after 2014, when there was a case at the Court of Criminal Appeals that really changed how DA supervision had to operate. And in response to that change, the legislature passed a new statute that said, okay, if you're not supervised by the DA for each of those 24 months, paying them $40 a month for that service, you still have to pay the DA's office $40 a month as a reimbursement of prosecution cost. We still together on this?
Yeah, so you're paying $40 either way, whether or not you're supervised by the DA's office.
If you're being supervised by the DA's office, you're paying $40 a month. If you're not, you're paying $40 a month to some other probation service, and then $40 a month to the DA's office as a reimbursement of their prosecution expenses.
How does someone come to be to be supervised by someone else besides the DA?
Some DAs just don't offer DA supervision anymore,
but they still get the charge for it.
They still get that separate $40 charge, but they're not
that's also
providing the
bullshit.
Supervision. So
there's all kinds of bullshit on this conversation.
All right, so we're almost through what you've got to pay.
I'm trying to
get out of the case.
I'm trying to keep a running tally here.
Yeah.
But
So let's say it's 2015, and you're one of these new folks who is in a county that doesn't offer DA supervision, so you're paying $40 a month to a different probation provider, $40 a month to the DA's office, whatever you're paying to the court clerk, cost administrator for your fines, fees, and court costs from the actual case. Let's say you get through all that and you're done, your case is over. You still got records out there. You got an arrest record from when you got arrested.
Right.
You've got all these court records. So that is can be a pretty big drag on a person, especially a young person, because a lot of the time people who were arrested for misdemeanor possession were young people. So in addition to all that, you really should expunge all these records. And being able to set a case up so that everything is expungible used to be a lot more difficult. The legislature has actually expanded expungement rights pretty dramatically over the last few years. But if you're eligible for an expungement, then you've got to not only pay an attorney to handle it for you, but then you've also got to pay the filing fees for the expungement and processing fees at the State Bureau of Investigation, or if, for instance, Oklahoma City requires another processing fee if you want an expungement through their system. So that's another, call it $2,500 when you include filing fees, attorney fees, processing fees to make it so that it didn't happen, right? So to make it so that the crime, legally speaking, didn't occur again, so that you're fully on the other side of it. You've gotten through probation and expunged it.
Right.
Yeah, those are all your...
I'm going to do a recap to make sure that I've got everything here. So we'll go with kind of the basic scenario we've been going.
Right.
So let's say that I put up $100 for my bond initially.
And we're just skating by the fact that if this had happened in your car, you might have some impound fees in addition to that. Right?
Good golly.
Right?
Yeah.
So yeah, just starting from the bond.
Right.
Starting from the bond out.
So I'll do just actual financial cash assessment. So $100 for the bond, and then there's the 3 half days of work,
Right, which you may have to,
you don't if
You
I
may
work
have- yeah.
and I don't have paid leave or
Right,
those kind
exactly.
of things.
Yeah.
And then of the various fines and fees, there was like a $300
Yeah,
one.
maybe a $300 fine, maybe a $50 victims compensation assessment.
Yep.
Yeah.
And then your attorney's fees as an average $2,000 maybe.
Let's say $1,500.
1,500. Okay.
Yeah.
And then 900. So 2 years at $40 a month is $960 in supervision, plus another $960 to the DA's office, plus another $2,500 for expungement.
On the very end, yeah.
The very end. Is there anything else?
You got the attorney fees. I think we're not counting all of your actual court costs. We've got the fines and the probation fees.
Okay.
But let's just call your court costs $700.
Right. Okay.
Okay. On any individual person. It's so even though you can quantify exactly what the costs are going to be, you can kind of see what you're going to expect a person to have to pay altogether. That doesn't, it's kind of like with the time off from work, right? And it's even kind of like with asking for the time off from work. Because if you go to your boss and say, I need time off from work to go to court because I'm charged with a crime,
right.
There's a cost being incurred there, but you don't know what it is exactly.
Right.
It's
not a financial cost, but it's
is it the promotion you're going to miss out on
in
a year because of this?
Yeah.
It's so like, yeah, we can figure out what it's actually costing people. It's costing people a lot. The criminal justice system imposes really, really heavy costs on people, but we can't even quantify all of those costs.
Right. So I actually did the math here, and the numbers we described came out to $7,070 for a simple possession.
Yeah.
And so
over the course of three and a half years, from arrest through, let's say, and again, we were kind of doing the speed it up. You plead out at your first opportunity. That's still your financial obligations increase dramatically over a pretty significant period of time when you're arrested for a crime. Right.
Well, and there's been plenty of stories about the percentage of Americans who don't even have the cash on hand to survive a $500 hit, like an emergency, right?
That's right.
And so if you owe $7,000 over 3 years, that's still a couple $1,000s a year that you didn't expect.
Yeah.
That's hard for any of us to come up with, and it's not like necessarily spread out in like 36 easy payments, right? Like, I mean, that's $7,000 is a decent car that you could buy, but without the opportunity. And so, like many Americans, maybe you have a credit card and you use that, then you're paying 15-20% interest on this the whole time. I, from personal experience, not criminal, but I got divorced 5 years ago, and I am hoping to pay off I used my credit card for some of my retainer on that, and I'm hoping to pay that off this year. It's been 5 years. I'm like, it was it's not brutal. An easy process. Yeah. And so, I think you've done an excellent job of illustrating how something as simple as simple possession that is now not a crime.
That's right.
But so I guess how it could totally change the course of someone's life.
Absolutely.
So what happens, Brian, if someone can't pay this?
If you can't pay your probation fees, for instance, or your court costs, then the DA's office will file an application to accelerate or revoke your probation. You will be subject to another arrest warrant that will have to be satisfied. If there's a bond associated with it, you will have to satisfy that bond somehow. You will have to, again, go to court. And if you can just pay if you can pay your fines and court costs and get up to date, they'll dismiss the application. If you can't, they'll keep you on the docket until you can. And if you are unable to, they'll put you in.
So if I think what you're saying in legalese is that if I can't pay at some point, like I can't pay my DA fees or whatever, they will arrest me and I go to jail. Let's back up to the very beginning of this story, and let's say I didn't have the $100 in the first place and I just stayed in jail.
Right.
How does that change the story? You still accumulate all the court costs.
You're still accumulating court costs.
You're still accumulating.
You're losing whatever. A lot of people. I've sat through a lot of arraignment dockets in my time, video arraignment dockets, where a judge in a courthouse is talking to people one at a time who are wearing orange or wearing stripes, and they're coming up to a video and they're asking for something to be done on their bond. The judge is setting their bond, and just one by one, lots of them are saying, "Can I please bond out? I got a job. I'm going to lose it if I can't get back to it." And there's nothing that
judges know.
I mean, judges could OR or PR those people so that they can go to work,
right.
But they don't.
As a judge, what is the reason not to do that?
What's the legal reason or what's the real reason?
Both.
I mean, I know that's kind of a silly
Yeah,
question.
no, both.
both. I think the legal reason is every person who has been charged with a crime is theoretically a risk to A, society, or B, of flight that they will not return to court.
Sure.
I mean, that's easy to not take seriously in lots of cases. Most of the people who get caught up in the criminal justice system aren't really a danger. I mean, but Andy here, who's just been arrested with a joint in 2014, is not a danger to society, and he's not a flight risk. This is his home. He's not going to run away for something like this. The real reason I think is well, I can speculate about the real reasons. I think a lot of it is that judges are constantly worried that they're going to let somebody out on an OR or PR bond or on a reduced bond even, and they're going to go murder a bunch of people, and then people are going to be like, well, Judge so-and-so.
The Willie Horton effect.
Kind of, yeah. I think there is a fair amount of that out there. But I also think that there is a real resistance within the criminal justice system to re-examine some pretty basic principles, some pretty basic facts about the way the system works, and I think that the bond companies have a lot to do with maintaining the cash bail system throughout the country. I think this is true.
And we've seen it at the State House.
Absolutely.
In the last couple of years, the bail bondsman up there advocating against some of these reform measures because it does threaten their livelihood. And I think that's for, Scott and I talk about this often on the show, that elected officials have an obligation to their districts, sure, and to their constituents, and arguably that there's a obligation. Maybe it's not arguably. Maybe they just have an obligation to trying to discern what is best for our state, right? And for the people of our state. And so when you have a group saying, listen, this is our jobs, well, I mean, sometimes things happen, right? Society evolves, it moves on, and at some point we have to come to terms with whether or not our decisions and how we treat people in these situations is what's best for our society to move forward.
Yeah. If you're saying that this injustice must continue because otherwise I will not have a livelihood, then I think we all need to ask ourselves some questions.
Yeah. No, I mean, it's just I don't know. I don't really have a thought. It's just mind blowing to me. I can wrap my head around, I think you can make a reasonable argument about whether or not things like fines and fees are an effective deterrent to crime, but I can understand why those exist. I think that you can ask good questions about whether or not they're effective, but the rationale is straightforward, I think. But the costs and the fees and the funds, and you got to pay the DA whether they supervise you or not, and if they don't supervise you, you got to pay somebody else. I mean, it's I want to say we don't make it easy, and the argument is, well, they're criminals, you shouldn't make it easy, and I guess maybe that's true to a certain extent. Maybe there should be punishment for punishment for crimes, but at the same time, you shouldn't. I don't know. I mean, do you see the general I don't even know what I'm trying to say other than it seems very. I was gonna say it seems punitive and well, yes, obviously, right? Of course, it seems punitive, but too much.
I think it's heavy-handed because of our belief. I mean, we are a law and order state, and I totally get. I think we as people like to assign labels of good and bad to people, right? It helps us sort who's good, who's bad, right? I'm good, you're bad, us, them. It differentiates, and we see this throughout history,
yeah,
right?
sure.
Like, and it's tribalism just of a judicial sort, right? And so I think if we can, it's easier to attribute someone who commits a crime, any crime, simple possession 5 years ago. Oh, well, they're a bad person. They, they had a joint. They must be a drug addict. They are probably dangerous as well. They, and if we let them out, then they're going to do something more. And we have this belief that it goes from a joint to you're murdering or raping somebody, even though we know that's not the case.
Right. Like you're right. I think you're 100% right that that's the cycle that goes on. Like that's the argument. That's the circle of reasoning. It's just that every single step in it is wrong, other than the fact that they had a joint, right? Like the fact that they had a joint is the only part of that that's like actually true.
Yeah.
And it is incredibly frustrating to me that like that and I know that, and I think like a lot of like this isn't like new. This isn't brand new information, right? Like. It's kind of like, it's like in mental health, right? Like we've known for decades that people that have mental illness are no more dangerous. They're in fact less likely to commit violent crimes than the population at large, but there's still this like stigma despite the fact that it's known, Mm-hmm. And I think the same is true with the population that enters their criminal justice system. And it's frustrating to me that it's taken this long for our leaders to like not only just tacitly recognize that, but also try and do some things that actively push back.
Right.
Well, I think a real point that can't be missed, though, and this kind of goes back to Andy's point about sorting people, trying to figure out who's good and who's bad. Go back to the. Sorry, I just thumped something. Go back to the point we were making earlier about the difference between posting a cash bond and using a surety bond. If you have means to post $1,000 cash bond, then already your outcomes are looking a lot better than the person who's got to take $100 and say goodbye to it forever.
Sure.
To use a surety bond. At every stage of the criminal justice system, having more money as a person coming from means, coming from wealth, is going to lead you into better outcomes. So if the criminal justice system is a mechanism by which we figure out who's good and who's bad, it's not. It's a mechanism by which we figure out who's poor and who's not.
That is an incredibly powerful point.
So to go back to our story, Brian, we didn't discuss what happens if I, as the perpetrator here, decide to go to jail. So I don't seek probation. I don't plea out. I just say,
you want your trial.
I want my trial.
Yeah.
What happens in that scenario?
That's a risky move, my friend, especially on a possession of marijuana charge, right? Because if they found it, then your argument for innocence in front of a jury is difficult.
Right.
But
I was just holding it for my friend.
Yeah.
You ever listen to The Sports Animal?
No.
There's like Pat Jones, who used to be the football coach for OSU. He's got his joke he always tells about players that would get caught with stuff. Now they always say, no, that was my cousin's dope. Yeah. It wasn't mine. Yeah. So it's his thing. He says all the time. He says, "Oh, this is my cousin's dope situation."
Yeah. But so if you stay in jail, let's say you stay in jail, right? And you want to, let's say that you're not charged with. Well, look, okay. I was going to try to make it more complicated and say, let's say this is an assault and battery, and you got into a fight. Okay. Either way, if you decide if you can't bond out and you want a trial, then you tell your public defender, they're like, all right, we're going to set this on trial track. It's going to take some time to get there because it is putting a jury together to actually try a case is a tremendously difficult and costly process. Mm-hmm. So it's a lot to get that done. There's a lot of people standing between you and a trial whenever you're starting. So it's going to be a little while for you sitting in jail. I would expect that if you, on your very first day, your very first meeting with your public defender, tell them, I am not going to take any plea. I am 100,000% innocent of this allegation, and I want a trial. Get me one as quickly as you can. They could maybe get that in 6 months, maybe.
Right.
So you're sitting in jail until that's done. If you win and you're acquitted, You get to get out. You get to leave. Wonderful.
You still have to pay
You
court
just
costs.
walk out. No, you don't have to. You
No
don't have to
court
pay
costs?
anything. No court costs. You walk out. You've been acquitted. You don't have.
It's not your fault.
Yeah, you're acquitted. But guess what? You don't get done for free, even though it's now available to you, an expungement.
Oh, really?
If you're acquitted, you can expunge the arrest records and the court records.
But you
But you still got to go pay for that. You got to pay the processing fees. You got to pay all of that. Yeah.
So it's $2,500 regardless.
Yeah, I mean, an attorney fee, but OSBI doesn't care that you were acquitted. They're still going to
Right.
charge you a processing fee to process your expungement.
So now let's say that in a much more likely scenario, you are convicted. You are now responsible for court costs, which are going to be massively larger because you had a trial and a jury and.
Yeah.
Like now it's not just like
Yeah.
the court costs for misdemeanor possession that the legislature
Yeah.
made up. Now it's like
Yeah, and it's whatever sentence that you were that was imposed by the jury. You found you, and the max, 5 years ago for misdemeanor possession was a year. So you could get a year in the county jail. You'd probably get credit for time served. So you'd only be doing another 6, and it's not day for day. So you would probably get out in another 90 days. So.
So what would your court cost be for a trial like that?
That's a good. I don't know. That's a good question.
Is there an option in between these two scenarios? So the first scenario was that I pled guilty, got probation, got out. I was able to go about my life, keep working or whatever. Second scenario was did not plead guilty, claimed innocence, stayed in, won or didn't win, whatever.
Won or didn't win, right.
Is there a scenario where a person could plead guilty but recognizes they can't afford probation for some reason and decides decides to do time served?
I mean, if a person, I've definitely, I know that a prosecutor will give you jail time in lieu of
So
other
I guess
kinds of.
that's my question.
If they want to give you probation, you're like, but I can't pay any of those things. Can I just do some time in jail instead?
Right.
I bet they'll take that.
No, this is real. Can you be like, look, I have a job. I want to keep my job. Can I be in jail at night? Like, can I come to jail and sleep? Can I come to jail on the weekends?
Yeah,
Oklahoma,
weekends.
Oklahoma County has a weekend jail program. They don't like it that much, though. People have you have to get to the jail by like 5 p.m. on Friday, and then you get out at like 10 in the morning on Sunday, and it's just really easy to miss that 5 p.m. on Friday check-in time. And it's I've seen it. I mean, I've had clients who did things like that in the past, but the last time I talked to anybody at the DA's office here in Oklahoma County about weekend jails, they were like, we're really not liking that too much anymore.
So to kind of bring this all like home to what has happened in Oklahoma this year specifically, there's really there's two main things that happened in Oklahoma this year, right? We got retroactivity for State Question 788, and then the other thing is the fines, fees, and costs now will not go to the court that assessed them, right? They will go to the general revenue.
They go to the general revenue fund, and then they go back to either the DA council or the courts. I think that's how that works.
So it's not just appropriated. I thought it was they all go into GR, and then the legislature appropriates whatever they're going to appropriate, and that's all the money.
But I think they appropriate it to those two entities.
Is it a 1-for-1? Like, you know what I mean? Like, let's say, like, I'm just making up like entities here. So tell me what the actual example would be. But like, let's say that the Oklahoma County District Court, is that a thing? Let's say that they assessed $1 million in fines, fees, and costs in the fiscal year 2020. Is the legislature has to appropriate them $1 million, or can they appropriate them $500,000, or can they appropriate them $1.5 million?
I'm not,
like, does the legislature get to appropriate whatever they want?
I'm not sure, but my understanding of how this worked was kind of that it worked the first way,
the 1-to-1.
Yeah, that it's one that whatever would have just stayed with that entity now does a detour through the general fund and goes to the appropriating agency, which in the case of the district attorney's offices would be the district attorney's council, which is how the DA council works now. They get their appropriations from the state, and it gets divided up among each DA's office. I think that's how it's still going to work. It just goes through the general fund first,
Right.
I think.
So my question was kind of related to where Scott was going with that, but let's say we change the system, right? So that we reduce these fees or change things. In your opinion, and again, this is one man's opinion, right?
Yeah.
But how do you see, like, what's a good way we could change things that would be meaningful to people, and what would the impact of that be on the state?
I think that, what do the courthouses need to operate? What do the DA's offices need to operate to fulfill their functions? Let's see what those numbers are, and then let's appropriate them the money that they need to do the jobs that they are supposed to do. Let's even say that we recognize that a lot of these people are overworked and underpaid currently, and let's pay them appropriately for their labor. That's a good start. If we just say, what do these entities need, and rather than sending them off to essentially extract their own funding from the community that they're technically supposed to be serving. I mean, you're represented by the DA who is prosecuting you, right? I mean, you're represented by the judge who's imposing sentence on you. I mean, so we all have an interest in seeing these public institutions work correctly and be appropriately funded, and seeing the people who run them be compensated for what they do. Right. I think that's where it should start.
It seems like it just seems like, from a common sense and then like a just, ethical, like legal moral standpoint, like these things should be totally separate, right? Like, I shouldn't have an incentive as a judge or a DA to impose a stricter fine because we need the money.
But it happens. And I remember a couple of years back, this is just ringing a bell, where there was like a judicial conference, and I think the judges got told, you got to start imposing like a specific fine for every DUI or something, or the court system isn't gonna operate. Things like that. It happens. And here's the thing that I really try to impress on people whenever I can: the extent to which what seems absolutely intuitively just brain dead fair to most people just has no interaction with the criminal justice system. At times, there was a bill that got passed off the House floor with 101 votes this last session. That was sponsored by Representative Forrest Bennett.
For those playing the home game, that's literally every member of the House.
Every single member of the Oklahoma House of Representatives.
That's happened like 2 times.
Yeah, and it was a bill to make it so that if you couldn't go to your court date because you were locked up in another county, that you didn't incur any penalty for that. And it just seems so bonehead obvious that is a fair thing. 101 people in the Oklahoma House voted for that proposition. But inside the criminal justice system, it is simply routine that if you are not there in court, regardless of where you are, regardless of whether we know you're locked up in a county somewhere else, bond forfeited, alias warrant entered. That's it.
That should also apply if you're in a hospital.
Yeah.
Right, because that happens too, right?
Yeah.
It's like he can't come to court. He's on a ventilator.
Yeah. Or yeah.
Right.
Yeah.
Like you shouldn't be fined for that.
Yeah. It's just it goes to, I think, really highlight the extent to which institutions change the people inside them, to the point where what seems absolutely common sense, fair to everybody, will just not even occur to the people inside the system, because that's the power of institutions.
So Brian, we've talked through a couple of fictitious scenarios here, and we said that a simple possession, like marijuana possession charge, might result in about a $7,000 cash outlay from that person.
Yeah, over like the next 3 years.
Cost of 3 years, right? And this was happening thousands of times a year, every year,
yes.
right? For years and years and years.
Yeah.
Now that 780 is passed, simple possession is no longer a prosecutable offense.
Not really. I mean, 788 made
788.
Misdemeanor possession by a person without a patient license a $400 fine only offense, and the new statute that goes into effect next month even spells out with a little more clarity how that stuff works. So we've essentially decriminalized simple possession of marijuana in Oklahoma, in a pretty substantial way.
And regardless, just the passage of 788 and medical marijuana laws, we've seen something like 4% of the population now.
150,000
people have a license, right?
Patient licensees.
It's been really fascinating hearing those numbers. So, like you said, we've effectively decriminalized marijuana for for most intents and
and
purposes.
really reduced the potential range of punishment for drug possession crimes across the board and property crimes
Right.
across the board. 780 and 781 really had a profound effect on the system.
So what is that reduction in fees, right? Like it's a reduction in revenue for the court system. All these people who used to be, and I mean, there was as we talked about early on in this episode, there is an expense that the court system, the judicial system incurs to process and do all this. And so there's not that expense, but there's also not that income.
Right.
Do you think that there's going to be a positive or negative increase or positive or negative impact on the net revenue of the judicial system because of these legal changes?
It's a very good question. And I don't know, now that we've had, so 780 and 781 went into effect July of 2017. So we've had about 2 years
Right.
of data to see like whether how the court systems are doing. I have not heard of any real
Right. Well, the
real dangers.
projection, right, was
Yeah.
that 780 would save us so much money,
Right.
and that that savings. I guess the assumption was that we were spending more money than we were bringing in, so that it cost more to process these individuals than it did what they paid, and so we would save money, and that savings should be redirected. That 781 said we should redirect that savings into creating drug treatment programs,
Right.
to help with that. To my knowledge, we've not actually set up or funded any of those programs yet.
I don't think we have. That's that's the 781 side of it. Well, so like first of all, the savings were intended to come out of corrections.
Right.
So, and if let's just, I mean, I think that will eventually bear out. I think that reducing who or just on a felony track from the very beginning is probably going to reduce the number of people overall who get incarcerated. That was the point. I think it's going to achieve that. But those savings are going to come on the correction side. The cost on the court side and on the DA side could really actually be substantial. And here's why, because I think a lot of where it's like my understanding from talking to people who are like daily practitioners in the criminal court still is that it's the misdemeanor revocation dockets where we're really seeing the effect of 780, because instead of all of these people who are on the felony track, they're now all lumped into the misdemeanor pile. And misdemeanors is typically where you train new prosecutors, right? If people are fresh out of law school, they go handle misdemeanors, and you divide those up among however many misdemeanor DAs you have, or if you're in a smaller county, you've maybe have one person handling misdemeanors and other people dividing up the felonies. But since so many more of those cases, instead of going to felony judges and felony prosecutors, are now all going to misdemeanor judges and misdemeanor prosecutors. And since that many more people being on probation for misdemeanors while having pretty serious substance abuse problems, because you don't, the 780 dealt with the more serious drug offenses, like cocaine, methamphetamines, things like that. You got a lot of people on misdemeanor probation who really do need pretty serious services, substance abuse services. They're not getting them. They're on these misdemeanor probation sentences that are again imposing these heavy costs on people because they still got to pay the $40 a month and all that. They're not being able to do it, so they're going into the misdemeanor revocation docket where we handle people who haven't been able to keep up with their fines or their court costs, and it's just an explosion of work for the line prosecutors and the judges who are actually responsible for that stuff.
Right.
So it sounds like while positive, it's definitely addressed some problems, but it's maybe created some new situations we're going to have to deal with.
I think that we are probably living through the beginning of a major change in what I'll call the market for criminal justice in Oklahoma, meaning not only the courts and the DAs and all that stuff, but the private practitioners. Like I have heard directly from a lot of people. I don't do nearly as much criminal defense work as I used to. It used to be all I did, and now it's very little of what I do. But the people who still do it every day are really seeing a change economically, and I think that it's going to Whenever you make a really major change like that, who knows what's going to happen?
Sure.
I think that we're moving in the right direction, but there is a lot that's going to have to get sorted out.
So that actually is a perfect lead in to the last question that I was going to ask you. So you're the, like, I don't know. I had a professor in medical school who would always say, if she was the benevolent dictator of the world, here's what she would do. So you're the benevolent dictator of criminal justice reform in Oklahoma. From where we are now, 780, 781, 788, kind of current situation, what are you, in your opinion, top 3 things that Oklahoma needs to do to address our problems in criminal justice reform? And I'm going to leave that super broad so you can kind of, what do you think the top 3 things are that we need to do that would make this a better system, both for the public at large, but also for people, defendants and otherwise, who interact with and use the system on a regular basis?
It's a great question. I love just being able to put that, that imagination hat on for a second. I don't know that I could think much beyond this, though. If I were given czar authority over the entire Oklahoma criminal justice system, I would spend all my time working to reform how juveniles are treated, how kids are treated. And I would probably expand my personal definition of kid to be anybody entering the criminal justice system at any time before they're 25. I mean, I
was going to say 24, but 25 works.
I mean, I've represented a lot of young people in the criminal justice system, and they're treated in different ways at different stages of their life and depending on what has happened to them. But we are absolutely brutal to young people in the criminal justice system, and it is a moral travesty, and we do it in lots of different ways. And if I had total czar authority to do whatever I wanted, I actually wouldn't be doing, like, trying to save money or any of that stuff. I would just be trying to fix that because it's terrible.
That sounds like a whole podcast episode right there.
That's a new series down the road. Brian, thank you very much for being here with us.
Thanks, guys. Appreciate it.
Thanks again to Brian Jones for joining us for this episode. Next week, for our 3rd and final episode in this series, we'll be joined by freshman member of the Oklahoma House of Representatives, Gary Mize, who entered the legislature after state questions 780 and 788 had both passed, to get his take on where we go from here and how we continue this trajectory towards reforming the state's criminal justice system. Now, before you go, please, if you don't mind, just take a quick minute to share this episode on social media, right? Like a quick tweet or a Facebook post goes a long way to helping this information get out to other Oklahomans. And the more folks that have information, the better we are as a state equipped to try to make some of this change actually happen. And if you're feeling extra generous, I know Scott and I would really appreciate if you would rate and review Let's Pod This in the Apple Podcast Store so that listeners can help find this a little more easily. Thanks. Have a great week.